So the last at the fourth treaty maxim, that is an important maxim which governs treaty formation and treaty termination, and that is rebus sic stantibus. The doctrine implies that a tacit condition set to attach to all treaties that they shall cease to be obligatory as soon as the state of facts and conditions upon which they were founded has substantially changed. It otherwise means when the existence or the development of a state stands in unavoidable conflict with its treaty obligations, the latter must give way for self-preservation and development in accordance with the growth and vital requirements of the nation. It is termination of a treaty if there occurs fundamental changes in the circumstances under which it was concluded. It relates to material change has occurred in political, economic, and social conditions of a state. This doctrine could be analyzed with reference to the doctrine of frustration of contract as we found under Section 56 of Indian Contract Act of 1872. So it recognizes that which gives a right to a party to terminate a contract if vital change occurred in the circumstances under which the contract was entered into. So, in relation to that, the Permanent Court of International Justice in the leading cases such as Anglo-French Treaty on Morocco, Sino-Bulgarian Treaty, and the Fisheries Jurisdiction case, it held these principles authenticity. Announcement of withdrawing from treaty obligations due to change in fundamental changes in the circumstances. So also in the same manner, International Court of Justice held this principle as a customary rule of international law in the important leading case, Fisheries Jurisdiction case in 1973 between United Kingdom and Iceland and Federal Republic of Germany versus Iceland, and that is another important leading case relating to this particular principle. Rebus sic stantibus, and also Article 19 of the Covenant of the League of Nations in 1920 provides reconsideration of treaty provisions which have become inapplicable, whose continuance might endanger the peace of the world. In the same manner, Article 10303 of UN Charter invokes that in case of conflict of obligations arising from any other treaty provision, the obligation of member states towards the present charter shall prevail, and Part 5th of the Vienna Convention on Laws of Treaties 1969 under Article 42 and 43 specifically deals with the invalidity, termination, and suspension of the operation of a treaty obligation under fundamental changes in the circumstances under which a treaty was signed. Further, Article 62 of the Convention expresses says that on the subject of the termination of a treaty relationship on account of change of circumstances. So also, Article 65 and 66 of the Vienna Convention of Laws of Treaty 1969 provides the same provisions regarding the very termination of a treaty due to fundamental changes in the circumstances. So, Professor J.G. Stark, in his conclusive opinion on this maxim, interpreted this provision as it involves a combination of two tests, while the existence of circumstances which constituted an essential basis of the consent of the parties to be bound by the treaty is a subjective criterion. The change must be so fundamental as radically to alter the obligation of the parties is an objective test. Besides that fundamental change in the circumstances itself does not terminate a treaty. It must be invoked by a party to the treaty in accordance with the procedure laid down as we found under Article 65 and Article 66 of the Vienna Convention on Laws of Treaty 1969. So, almost in this video, we have discussed the last most important treaty maxim, and that is Box 6 Stantibus, which deals with the very question of how a treaty could be terminated and what conditions or circumstances are responsible for termination of treaties. So, in that connection, we have discussed the very doctrine of frustration, as we found also under Section 56 of Indian Contract Act of 1872, which provides those conditions under which the doctrine of frustration led to cancellation of a contract or termination of a contract. So, we finished the very subject treaty, which is an important subject in international law. So, we have finished all the four important maxims relating to formation, continuance of a treaty obligation by a signatory state, and so also there are certain treaties which are automatically applicable to those third states which were not the signatory or members to a treaty, such as treaties relating to terrorism, piracy, genocide, etc. So, that way we have finished the treaty maxims and all those provisions relevant in relation to the Vienna Convention on Laws of Treaties, which was enacted in 1969 under the guidance of United Nations organization.